If you have a job, there's a 90% chance that you believe this massive lie. You've been told that if things go wrong at work, if you're being harassed, or if your boss is stealing your overtime, or if the workplace just becomes toxic, well, then there's a dedicated department designed specifically to protect you, human resources. But here's the hard truth. HR is not your friend. They don't work for you. The company signs their paychecks, which means their actual job description is to protect the company from you. I'll be exposing 4 brutal tricks that HR uses to quietly cheat employees out of their money, their legal rights, and ultimately, their jobs. Stick around, because the last trick we're covering has actively stripped millions of workers and billions of dollars. And you probably signed up for it without even knowing. Quick disclaimer before we jump in. This video is for educational purposes only and does not constitute formal legal advice. Every workplace situation is unique, and if you have questions about your specific case, please reach out. So trick 1, the trap of the open door policy. Let's start with trick 1. Flip through almost any employee handbook and you'll see it written in warm, inviting language. Hey, our door is always open. Bring us your complaints in confidence. We guarantee a retaliation-free environment. It sounds incredible. It feels safe, but it's a trap. When you walk through that open door and share a complaint in confidence, that confidentiality almost instantly evaporates. In the real world, HR routinely uses this open door policy as a corporate early warning system. It gives them a heads up on potential troublemakers or liabilities before a problem spreads. Instead of fixing the manager you complained about, HR often shares your exact words with them. Suddenly, your manager knows you're a threat. Within weeks, you might notice a sudden shift. You're getting written up for vague performance issues. Your schedule changes. And then shortly after that, you're let go for a nebulous reason like not being a culture fit. Legally, you're only protected from retaliation if your complaint falls under very specific legal categories, like discrimination or whistleblowing. HR knows that most general complaints about company policy violations aren't legally protected. They will tattle to management, and you will be the one escorted out the door. Trick 2, the illusion of workplace investigations. Trick number 2 happens right after you fall for trick number 1. It's the workplace investigation. Let's say you report something serious, like a boss who's harassing team members. Well, HR representative nods empathetically, takes meticulous notes, and says, thank you for coming forward. We're launching a formal investigation. You breathe a sigh of relief. You think justice is coming. But inside a private company, there are no due process rights. That investigation isn't designed to find out the objective truth. It's designed to build a legal shield for the company. If a lawsuit is brewing, HR's job shifts to documentation management. They will often interview the witnesses who support management's side while conveniently glossing over the coworkers who back up your story. They'll stop putting things in email and then shift all communications with you to phone calls or in-person meetings so there's no paper trail. Meanwhile, behind the scenes, they work with your supervisor to paper your file, creating a paper trail of minor infractions so that if you ever do sue, they can present a whole folder to the judge and say, see, we didn't fire them because of their complaint. We fired them because they were a bad employee. When the investigation wraps up, the final report almost always reads, no evidence of wrongdoing found. Trick 3, the documented lie. This brings us to trick number 3. HR can and will lie to protect the bottom line. In day-to-day interactions, HR doesn't need to lie. But when a legal or financial dispute arises, remember this: there is no legal requirement for HR to be honest with you. We see this most commonly in performance improvement plans, or PIPs. HR will often back up managers who write flat-out untruths in your write-ups. Oh, they'll claim you were constantly late when you weren't, or that you were insubordinate when you simply asked a clarifying question. Because defamation laws have very little teeth in the workplace, HR knows they can get away with it most of the time. Even worse, if a case goes to a deposition or a formal hearing, HR representatives will frequently suffer from corporate amnesia. They will claim under oath that they gave you verbal warnings they never actually gave, or deny that anyone else ever complained about that same toxic manager. Why? Because telling the truth could cost the company millions of dollars and cost that HR rep their own paycheck. Now for trick number 4. And this is the absolute worst trick on the list. It's an insidious corporate maneuver that has quietly stripped millions of working class people of billions of dollars in stolen wage and damages and their constitutional rights. It's called an arbitration agreement. Think back to your first day at your job. You're excited. You're happy. HR hands you a massive stack of onboarding documents. Well, nestled somewhere on page 42 of that handbook, or maybe as a standalone digital form, is a clause that says that you agree to arbitration. If you refuse to sign it, they'll pull the job offer. So, like most people, you sign it without even reading it. What did you actually just sign away? Well, an arbitration agreement states that if the company breaks the law, if they steal your overtime or discriminate against you or wrongfully fire you, you're legally forbidden from suing them in a public court of law in front of a jury of your own peers. Instead, you're forced into private, secret arbitration. The judge is an arbitrator, usually a retired corporate defense attorney who is selected and paid hundreds, if not thousands of dollars an hour by the company that you're suing. If you think a private arbitrator is going to consistently side against the entity paying their massive bill, think again. The settlement value of employment cases drops catastrophically the moment they're forced out of real courts and into arbitration. But it gets even darker. Most of these agreements include a class action waiver. So imagine your company systematically steals $2,000 of overtime from you. $2,000 might not sound like a lot of money to an individual, but it's not enough to afford a lawyer to fight a massive corporation in private arbitration. The cost of the fight outweighs the prize. Normally, you'd team up with 200 of your coworkers who also got cheated and file a class action lawsuit. But because of that tiny signature on your first day, none of you can do it anymore. The claims die, the lawyers turn down the case, and the company gets away with systemic theft. Look, to be clear, I don't believe that every HR representative is an evil person. Many enter the field genuinely wanting to help people, but the system is designed so that their professional incentives are completely misaligned with your well-being. Their mandate is corporate risk management, not worker advocacy. So, how do you play the game when the deck is stacked against you? Well, first, never just go to HR verbally. Always put your complaints in writing, clearly stating the facts. Second, look through your onboarding paperwork right now to see if you signed an arbitration clause. Some states allow you a 30-day window to opt out when you start. And finally, if you are facing severe misconduct, speak to an employment attorney right away before you walk into HR's office. If this video opened your eyes, hit that like button and subscribe. Let me know in the comments if you want a dedicated breakdown on how to beat or avoid forced arbitration clauses legally. Protect yourselves out there, and I'll see you in the next video.